Welcome back. Glad to have you with us. Glad to be with you. Really thrilled to have Roger Pilon with us. He is the founder and director of the Cato Institute's Center for Constitutional Studies. We've been talking about everything from the Declaration of Independence, the Federalist Papers, the Anti-Federalist Papers, the Constitution, the changes that were literally voted on paper, and changes that were simply interpretations of the Constitution. And we're going to continue with this. We're talking right now about changes from the 50s, 60s, and 70s. Roger, you want to finish up on that?
Yes, Gary. I want to illustrate some of the abstract points I just made. But first of all, let me state those points in perhaps in a little different way. You had these two schools of thought about the proper role of the courts under the Constitution now we're talking about the late 50s into the 60s and into the 70s. As the Warren and Burger courts became increasingly active, you had liberal activism, you had conservative reaction calling for judicial restraint. And the way much of what the liberal Warren and Burger courts were doing was long overdue, as in the civil rights area, for example, and in certain criminal law areas. But others of their decisions were simply, there was no basis for them whatsoever. The judges were, as the conservatives rightly said, applying simply their own values or their conception of evolving social values to reach the law, but to make the law rather than to find the law that was there to be recognized. And so you can think of it this way. The liberals were calling upon were finding law, making law that reflected the social values of the elites. The conservatives were saying, no, this belongs to the people to decide. Here's a case in which the liberals got it right. It's Griswold v. Connecticut in 1965. And that was a case that challenged a Connecticut statute that criminalized the sale and use of contraceptives. Now, you had conservatives saying, well, that's perfectly okay, that's exactly what states should be allowed to do. You had the liberals saying, correctly in my judgment, no, that the right to sell and to use contraceptives may not be one that you find in the Bill of Rights. Obviously, when they wrote the Bill of Rights, they didn't include the right to buy and sell, to sell and use contraceptives. They included the Ninth Amendment, which says the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. This was one of these unenumerated rights. And so the court came down in a divided opinion, saying, yes, there is a right to sell and to use contraceptives. There the liberals had it right. The conservatives, calling for judicial restraint, would have left that to the state of Connecticut to determine. A similar case a year later in 1967, 2 years later, 67, Loving v. Virginia, which was a challenge to a Virginia statute that prohibited interracial marriage. There the court said, no, you've got a right to marry whomever you wish. That's an issue which is before the country today, of course. And so here is another case in which the conservatives lost, and rightly so. But in other cases, and here I'm going to give you one that is controversial to this day, and that's Roe v. Wade, the abortion decision. This is a case that involves the question, when does a right claiming life begin, or when does murder begin? And it involves very disputed answers to those two questions. And it involves at bottom a police power question, because the question of when does murder begin is something for the police power to determine, but the general police power doesn't belong to the federal government. It belongs to the states. So here's an example of a case that should have been left to the states, which, by the way, when Roe v. Wade came down, they were already moving, several of them, to liberalize their abortion laws. And so the court took it upon itself to decide this, and it's been controversial ever since. This is a case, as no less than Ruth Bader Ginsburg said, should have been left to the states. So you had these two schools vying for thought, and as I said before the break, neither of them went to the core of the matter, and that opened the door for a third school of thought to come along, and that's the school of thought that I belong to and was in the early stages of developing when I was a graduate student at the University of Chicago. Bernie Segan, who was teaching out at the University of San Diego, Richard Epstein at Chicago, Randy Barnett, who was a law student at Harvard at that time. We were all there in those early days in the mid to late 70s developing this third school of thought, which calls for returning to the Madisonian Constitution as completed by the Civil War amendments, and therefore calling upon the court to hold the Congress to its enumerated powers on the one hand, and on the right side to protect rights both enumerated and unenumerated. That is to say, neither ignore the rights that are there to be protected, whether enumerated or not, nor invent rights out of whole cloth because they happen to reflect yours or your conception of evolving social values. So that's the third school of thought. Call it the classical liberal or the libertarian school of thought, and it stands between, one might say, above those two other schools, the judicial restraint school of conservatives and the judicial activism school of liberals, although in recent years those two schools have flipped depending upon who's sitting on the Supreme Court, with liberals today condemning many of the conservative court's decisions as activist and conservatives condemning many of the court's decision as too restrained. So there's where we are. That's the abstract thing, and I've given you a couple of cases to illustrate how these two schools, or these three schools, operate.
Let me just take one of those examples. How much time do I have left here, Brian? Where am I at? I've lost track.
You have about 4 minutes.
All right. This gives me more than enough time. I want to go back to the abortion issue,
Sure.
because it sounds to me like you're saying, and if it is, this is where I stand anyway, that states decide what's first-degree murder, second-degree murder, what's a felonious, what punishment, et cetera. So they get to decide if it's murder or not the federal government. Is that essentially what you're saying? In other words, the state of Missouri...
That's right. Here, in fact, I can illustrate it a little more clearly this way, Gary. I think we'd all agree that if you take a baby's life a day after birth, it's murder, right?
Right.
I mean, that's infanticide. Well, what's the difference between taking the baby's life a day after birth and a day before birth? Well, it turns out there's no difference, is there? I mean, is the fact that you do it in utero, you avert your eyes from what you're doing, make a difference? Of course not. Well, if that's the case, then what about 2 days before birth or 3 days? And you start working your way down that 9-month gestation period, and you find that it's difficult to draw a principled line. We've tried it in various ways. We've used quickening, we've used brain waves, we've used heartbeat, we've used feeling pain, we've come up, viability outside the womb and so forth. But these all tend to smack of arbitrariness. When you get down at the other end, you do find a principled line, namely either conception or implantation, but you also find that you've lost a lot of people along the way, and so you've got a very controversial line there, and so you're now dealing with a question that reasonable people can have reasonable differences concerning. And so this is one of these classic areas where you have to draw a line. And this is one of the areas where, because it is a police power issue of where to draw the line, just as you said, where do you draw the line between first and second degree murder, between murder and manslaughter, between what punishments to apply to this? These are all state determinations under our system, and you find that different states draw them at different places. And so if we had left this to the states, you very likely would have a situation, for example, where Utah would have a very strict abortion law, and right next door in Nevada you might have a liberal abortion law. And that's the best you can do, it seems to me, under a deeply controversial issue of this kind.
Yeah, there is no, I think, perfect solution.
Right.
But I think if this had been handled by changing of folkways and mores over the course of years, then I think we would have been in a much better position than having the courts come down and just say, this can't be done. All right.
Oh, absolutely.
We have just a few minutes left before we wrap up here. When we come back, I will talk to Roger Pilon from the Cato Institute about what it might take to reverse all this. Can it be done judicially? Can the courts ignore stare decisis and just say, yeah, this was wrong? Will they reverse themselves? We'll find out when we return. You are listening to The Gary Nolan Show. It is the Zimmer Radio Network.